Appearances.
Me from the.
With utmost respect to my Lord.
Go ahead.
With utmost respect to my noble Lord, I am H.A. Obeito. Humbly, my Lord, I appear for the claimant.
Any other appearance?
Respectfully, Your Lordship. I'm I.C. Duke.
Yes.
Humbly, I appear for the defendants.
Very well. Here's the judgment of the court. This action was commenced by a general form of complaint dated and filed on the 16th November 2020, wherein the claimant sought the following reliefs against the defendants. 1, an order directing the defendants to pay the total sum of 138,137,926 naira 41 kobo, being the total amount outstanding as salary arrears, shortfalls in salaries due to allowances, which is also known as DTA, leave allowances, severance and furniture allowances, which the claimants are legally entitled to be paid as former or ex-political office holders in Okehi Local Government Council, having held the positions of chairman, vice chairman, secretary, councillors, supervisors, and special advisors, respectively thereof, from 2013 to 2016 political dispensation. 2, an order of perpetual injunction restraining the defendants, their agents, privies, or anybody acting through them or on their behalf from withholding the payment of the said salary arrears, shortfalls, duty to allowances, leave allowances, severance, and furniture allowances, as well as other benefit due to the claimants as former chairman, vice chairman, secretary, councillors, supervisors, special advisors in Okehi Local Government Council from 2013 to 2016 as provided for under the Remuneration of Certain Public Political Officers Amendment Law number 1 of 2006 and Revenue Mobilization Allocation and Fiscal Commission Package 2009. 3, 21% interest on the said outstanding sum of 138,137,926 naira 41 kobo from the commencement of this suit till the delivery of the judgment thereof, and 21% interest thereof from the date of judgment or the judgment sum is liquidated. And 4 is an omnibus prayer. Claimant's case, according to their statement of fact, is that they were ex-political officers. Whose phone is that? Please put your phone in silent. The claimant's case, according to their statement of fact, is that they were ex-political office holders in Okehi Local Government Council of Kogi State from 2013 to 2016. They claim they were entitled to be paid certain remuneration and allowances as former political office holders in the first defendant by virtue of remuneration of certain political officers Amendment Law number 1, 2006, the Revenue Remuneration Package for Political, Public, and Judicial Officers in Nigeria, and also by virtue of the resolution passed by Kogi State House of Assembly. The defendants aver that, the claimants aver that defendants are still indebted to them even after their tenure in office. They went on to state that they were entitled to a total sum of 173,593,789 naira 79 kobo, and they were paid a total sum of 35,455,863 naira 38 kobo as deposit by the defendants, thereby leaving the total sum of 138,137,926 naira 41 kobo unpaid till date, despite repeated demands until when they left office. They were not paid, which resulted in them instructing their solicitor to demand for same. The defendants, despite being served with letters of demand failed to respond to same, which implies that they accepted claimant's claim. Excuse me. Defendant filed their statement of defense, which was subsequently amended, wherein they averred that claimants were political office holders who were out of office from January 2015 to October 2015, subsequent to a judgment of High Court of Kogi State. They maintained that the purported resolution by the State House of Assembly was not binding and does not apply to the claimants, and that correct and approved salary for political office holders is contained in 2007 remuneration report, and that the claimants were paid according to its provision. In continuation, they averred that the third, seventh, and eighth claimants were appointed by the first claimant after his removal from office by the High Court of Kogi State, thereby rendering their employment invalid. Defendants continue that the claimants have no legal competence to dispute any figure relating to their allowances without input from the defendant, and they do not owe the claimants any of the allowances claimed. Defendants stated that the suit of the claimant is an afterthought, clumsy, frivolous, and that claimants are not entitled to the relief sought, urging the dismissal of the suit in its entirety. At the close of pleadings, parties bid their respective counsel inform the court of their voluntary consent to have this case argued on record, which is pursuant to Order 38, Rule 33 of the rules of this court. By this special procedure, parties have dispensed with the need for oral trial, and the case is to be decided on the pleadings of parties, written witness statement, and documents front-loaded on record. In other words, they have voluntarily agreed to dispense with cross-examination, having settled all their issues by their pleadings. Subsequently, parties were ordered to file their respective written addresses. As it is customary to do in this special procedure, then counsel on behalf of the claimant filed its final written address first and followed by the defendants. I have reduced the pertinent part of the final written addresses of parties into the body of this judgment. So I will now go straight and read out the decision of this court. Upon a careful consideration of the originating process, along with its accompanying processes, the amended statement of defense, together with all processes filed along with it, and the final written addresses of parties, I am of the firm view that the issues that will best determine this case are as follows. 1, whether by virtue of the judgment of the Court of Appeal made on the 23rd of October 2015, and the 3rd, 7th, and 8th claimants were validly employed, and the claimants are entitled to be paid for the period they were not in office. And 2, whether the claimants are entitled to the relief sought. Respecting issue 1, claimants by their statement of facts averred that they were past local government executive members during the 2013-2016 political dispensation. In support of their averment, they annexed their certificate of returns and letters of appointment accordingly. I've perused the said certificates of return and the several letters of appointment as applicable, and I find that truly claimants were ex-political office holders, particularly ex-council members in the first defendant. It is worthy of note that while the defendants are not disputing the status of the other claimants, they are disputing the status of the 3rd, 7th, and 8th claimants as ex-political office holders. See paragraph 9 of the amended joint statement of defense. It is their position that the 3rd, 7th, and 8th claimants were never bona fide members of the executive arm of local government because the appointment was made by the first claimant after his removal from office by the Kogi State High Court, sitting at Kotonkarifi. I have gone through the records of this court with particular attention at pages 98, 110, 113, and 114 of the record, wherein one can find the letters of appointment of the 3rd, 7th, and 8th claimants. While the 3rd and 7th claimants were appointed on the 29th December 2014, the 8th claimant was first appointed on the 1st of August 2013 as senior special assistant to the first defendant, and subsequently appointed on the 29th of December 2014 as special advisor to the first claimant on the 29th December 2014. From the documents on record, the decision of the High Court Koton-Karfi, which sacked the first claimant who appointed the third, seventh, and eighth claimants, was delivered on the 8th of December 2014. The said decision of the High Court Koton-Karfi sacking the first claimant and other local government executives was subsequently set aside by the Court of Appeal Abuja Division in an appeal case number CA/A/194/2015. I bear in mind the position of the defendants by paragraph 16 of the amended joint statement of defense that claimants cannot ask this court to sit on a matter that has already been decided by the Court of Appeal. Learned counsel on behalf of the defendants be the arguments on issue 2 in his final written address submitted that documents and statutes must be given their literal meaning and that a party cannot infer into the judgment of court what is not contained therein. He posited that the judgment of a Court of Appeal does not contain monetary orders. Therefore, claimants are not entitled to be paid for the months they were out of office by the judgment of the High Court of Koton-Karfi, which was set aside on appeal. First, let me say that the judicial powers vested in superior courts of record, including this court, by virtue of Section 6 of the Constitution of Nigeria 1999 as amended, hereinafter referred to as the Constitution, does not extend to this court being a court of subordinate jurisdiction to sit as an appeal on the decision of a Court of Appeal or to subject same to interpretation. This is simply because the law has become ensconced that a court cannot subject the judgment of another court of coordinate jurisdiction or that of a superior court to interpretation or review. See the case of Idigbe and another versus Keystone Bank, limited citation provided. In fact, the court held in the case of Grace Auto Supply Company Limited and Akib, citation provided, that a judgment of the court of law can hardly be accommodated under the words quote, other written instrument, under 1 of the 46 of Lagos High Court Civil Procedure Rules 1994, under which the appellants file the application for the interpretation of a consent judgment, in that case of the 4th of May 98. And as such, the judgment of court of law cannot be subjected to interpretation by a court of coordinate jurisdiction like a deed, a will, or an instrument containing right and obligation of parties. Therefore, it is clear that judgments of court are not instruments that can be subjected to interpretation like normal documents, contrary to the position of learned counsel for the defendants. However, the point must be made that by virtue of the provisions of Section 287, subsection 2 of the Constitution, the decision of a Court of Appeal shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Court of Appeal, and which court includes this court, that is the National Industrial Court of Nigeria. Although what claimants are seeking in this case is not strictly the enforcement of the decision of a Court of Appeal, rather an application of terms of the said judgments to the case of claimants as it pertains to payment of their salary. Differently put, what is the effect of the said judgment of the Court of Appeal on the claims of the claimants of salaries for 10 months they were out of office by virtue of a judgment that has been set aside on appeal? A court has power to look at and apply the exact terms of the judgment brought before it, and doing such cannot be honestly interpreted as engaging in the review or interpretation of that judgment. See the case of, the case of Idigbe and another versus Keystone Bank Limited Supra. Thus, there is nothing stopping a court from expressing its views on the relief sought, taking into account the terms of the said judgment. See the case of Nigeria Industrial Development Bank and another versus Limani, Nigeria Enterprises Limited, citation captured. In my humble view, although the decision of the High Court Koton-Karfi was valid until set aside by the Court of Appeal, the moment it was set aside, it is as if the first claimant never left office. Thus, the appointment of the 3rd, 7th, and 8th claimants, which were obviously done after the decision of the High Court, has been resuscitated and are so deemed to have been done when the first claimant was validly in office. This view of mine finds its statutory expression in the fact that The system of democratically elected local government council has been constitutionally guaranteed by Section 7, subsection 1 and Section 8 of the Constitution. See the case of Friday and Governor of Ondo State, citation captured. Also, by the provisions of Section 19 of Kogi State Local Government Law 2000, as amended hereinafter referred to as LG Law, appointments into some positions have been statutorily protected. Thus, it means that the position of the first claimant who appointed the third, seventh, and eighth claimants in line with Section 19 of the LG Law is statutorily protected. In the case of Governor of Kwara State and Ojibara, citation captured, wherein the Supreme Court held that improper removal of an office specifically protected by law would be deemed a null act, and that in the circumstances of the case, the Court of Appeal pronounced the removal from office of the appellants from office as null and void, which consequence would be that in the eyes of the law, the respondent had not been removed from office. The import of the above decision is that the removal of the first claimant from office, which has been nullified by the Court of Appeal, has the effect of claimants never leaving office under the law. The effect of the above is that the appointment of the third, the seventh, and eighth claimants have been legitimized by the decision of the Court of Appeal nullifying the removal of the first claimant and the other local government executives from office. Be that as it may, parties are added that by the judgment of the High Court of Koton-Karafi, claimants were sacked from office, pursuant to which they were not paid salary for 10 months, which judgment was subsequently reversed by the Appellate Court on the 23rd of October 2015. According to Learned Counsel, on behalf of the defendants in his final written address, since the decision of the Court of Appeal contains no consequential orders as to payment of salaries to the claimants cannot read into the judgment what is not contained therein. It is a submission of Learned Counsel on behalf of the defendants that the court should interpret the said judgments of the Court of Appeal by using the ordinary meaning of the words used, and which specifically does not include monetary orders. It is in my humble view that going by the Court of Appeal judgment, setting aside the order of the High Court of Koton-Karafi, which nullified the decision of the claimants, which nullified the election of the claimants. Claimants are thus entitled to be paid for the 10 months, that is, from January to October 2015. They were out of office by virtue of a judgment that was set aside. It is my further view that going by the Court of Appeal judgment, claimants never left office because the order of court nullifying their election has been set aside for being invalid. As such, claimants are entitled to be paid for the months they were not in office. Question 1 is thus resolved against the defendants and in favor of the claimants. Now to question 2. The dissertation or controversy under this issue going by the pleadings of parties is whether or not claimants are entitled to be paid the monetary sums claimed by them in this case. I've already set aside the relief claim by the claimants. Just a minute. Sorry, I will take this again. Of the relief claim, the most principal one by the claimants, the most principal one from which other reliefs take their lives is relief 1, wherein claimants are seeking an order of this court directing the defendants to pay them the sum of 138,137,926 naira 41 kobo, being the outstanding salary arrears, shortfalls in salaries, due to allowances, DTA, leave allowances, severance, and furniture allowances, which they are legally entitled to be paid as former or ex-political office holders in the local government during 2013 to 2016 political dispensation. It is pertinent to state that claimants in this case by relief 1 are seeking for special damages, and the position of the law concerning special damages is that it must be specifically pleaded and strictly proved by evidence, as also argued by Learned Defense Counsel. See Union Bank and Inwaku citation captured, Onyora and another citation provided, Adekan B and Oseni and another citation captured. Thus, claimants must particularize their claims on special damages and also prove their entitlement to the amount claimed as special damages. Claimants must satisfy the court as to how the sum claimed as special damages was quantified. The court is not allowed to make its individual assessment, but must strictly act on the evidence before it, which establishes the amount to be awarded. See the case of Alaji, Otaru, and others limited. Alaji, Otaru, and Sons Limited versus Idris and another citation captured. According to claimants, defendants are still indebted to them in the above sum. Defendants on their own part, read paragraphs 10 to 13 of the amended statement of defense stated that the annual basic salary, severance allowances, furniture allowances, annual leave allowance of the chairman is 908,312 naira, 272,493 naira, 2,724,936 naira, and 90,831 naira accordingly. It is equally their position that the annual basic salary, severance allowance, furniture, and annual leave allowances of the vice chairman is 2,853,056 naira, 2,559,168 naira, 2,559,168 naira, and 83,305 naira 60 kobo. Accordingly, while supervisory council or secretary is entitled to the sum of 2,559,168 naira, 2,559,168 naira, and 83,305 naira 60 kobo accordingly. The point must be made here that it is the duty of the claimants in this case to establish their entitlement to the sums claimed in respect of each of the claimants by credible evidence which are of such nature or character that will satisfy the court that they are truly entitled to. See the case of NDPAC, NIPP versus Hula citation captured, the case of Ojiako and Nwabuisi citation also captured. Proof of entitlement in this instance, where claimants are claiming arrears of salaries and allowances, often by reference to an instrument which grants it. Claimants in this case are relying on the remuneration of certain political officers law, amendment law number 1, 2006, hereinafter referred to as the 2006 second amended law, and the remuneration packages prescribed by the Revenue Mobilization Allocation Fiscal Commission in 2007 and 2009. See paragraphs 5 and 6 of the statement of facts. However, it is worthy of note that claimants only place before this court the 2007 recommendation of the RMBFC without the 2009 recommendation, which they are equally relying on. See pages 89 to 96 of the record. Thus, the 2009 recommendation of RMAFC that claimants pleaded and relied on in support of their case in paragraph 6 of their statement of fact is not before the court. It is a tried position of the law that it is the duty of a party who relies on the document in support of his case to place same before the court. In fact, claimants ought to have placed the said 2009 recommendation, which was pleaded in this court, especially in view of the special procedure of argument of record adopted in this case. The law is clear that where a party pleads a document and fails to produce a copy of the document pleaded, the provision of section 167, paragraph D of the Evidence Act 2011 will be invoked against him. See the cases of Adenle and Ulude citation captured, Mabogunje and Adewumi citation equally provided. It is in consequence that I find that a failure of the claimants to place before the court the 2009 recommendation of the RMAFC, which they have pleaded and relied on in this case in proof of their entitlement, is fatal to their case. I perused this 2007 recommendation, which is before this court at pages 89 to 96 of the record of court. It is obvious from its content that there are clear provisions for the annual basic salary and allowances of local government council executives like chairman, vice chairman, supervisor, secretary, and special advisor. It is equally clear from the perusal of the recommendation, specifically the reviewed remuneration package for legislature at the federal, state, and local government level at pages 94 to 96 of the record, that there are specific recommendations on the basic salary and allowances of the legislature at the local government council, which are legislative leader, deputy legislative leader, and councillor. Albeit, claimants, apart from relying on the recommendations also made in 2006, that is the second amended law, a fulcrum of their case. The 2006 second amended law, which claimants are relying on, only applies to special assistants to local government chairman. None of the claimants is a special assistant. However, the point must be made that this court, just like every other superior court of record, by virtue of the provisions of section 122, subsection 2A of the Evidence Act 2011, shall take judicial notice of all laws and enactment and any subsidiary legislation. It is in the exercise of this power that this court takes judicial notice of the provisions of remuneration of certain public and political office holders law of Kogi State 2000, hereinafter referred to as the principal remuneration law, which the second amended law sought to amend. It is the principal law that applies to claimants and not the second amended law 2006, which they are relying on. According to the provisions of section 1, subsection 4 of the principal remuneration law, as amended by the second amended law 2006. Excuse me, just a minute. I need to get them to on again. Just a minute. According to the provision of section 1, subsection 4 of the principal remuneration law as amended by the second amended law 2006, the following local government executives, namely chairman, vice chairman, supervisors of local government, secretary to local government, and special assistants, are to be paid in accordance with first schedule of the law. By the combined effect of the provision of sections 1, 4, and 3 of the principal remuneration law as amended by the 2006 second amended law, salaries and other remuneration of those local government executives listed above shall be charged upon the Consolidated Revenue Fund of Kogi State. Claimants were chairman, vice chairman, supervisors, special advisor, and councillors. It therefore means that the salaries and emoluments of the first 7th and 9th to 17 claimants are to be charged from the Consolidated Revenue of the Consolidated Revenue Fund of Kogi State. The 8th claimant is not covered under the said law because he was a special advisor and his office was not covered by the said law. It is equally clear from the provision of the said law that salaries payable to claimants as local government executives, specifically as chairman, vice chairman, supervisor, and secretary of the local government, as contained in Schedule 1 of the Principal Remuneration Law as amended. The said law and the schedules does not cover special advisors to local government chairman and councillors. Those positions are not specifically listed in Section 1.4 of the Principal Law as amended, as I've stated earlier. In fact, from the letter of appointment of the 8th claimant at page 114 of the record, what she's entitled to as salary was clearly stated. In fact, for the sake of clarity, I will capture the salient part of the said letter, which says thus, I quote, appointment as special advisor. This is to inform you that you have been appointed as special advisor to the Honorable Chairman. You shall be on a monthly salary of 100,000 Naira with effect from 29 December 2014. It is hoped that you will cooperate, dedicate, and be loyal to the local government council, unquote. The contents of the above letter of appointment of the 8th claimant is unambiguous. It clearly states that claimant is entitled to only 100,000 Naira as monthly salary and not the sum of 250,000, which is being claimed as the monthly salary of the 8th claimant in paragraph 40 of the statement of facts. It is equally clear from the above content of the letter of appointment that there is no provision for leave allowance to be paid to the 8th claimant, contrary to what is being claimed in paragraph 41 of the same statement of facts. There's equally no provision for payment of furniture allowance or severance allowance to the 8th claimant in the above letter appointing her, contrary to the averments of the claimants in paragraph 43 of the statement of facts. In fact, there is no other document or instrument which supports the claims of the claimants in respect of the 8th claimant to the sum of 6,573,201 naira 73 kobo claims as arrears of salaries, shortfall in salaries, furniture, and severance allowances in the statement of fact. I say so in view of the fact that even the remuneration packages issued by RMBFC 2007, which claimants are relying on in this case, which are on pages 89 to 93 of the record, shows different amount as entitlement of the special advisor in the 3rd tier of government. Specifically at page 90 of the record shows that the recommended annual basic salary by the RMBFC for a special advisor like 8th claimant is 760,276 naira. The monthly basic salary of a special advisor would then be 63,339 naira 67 kobo, in contrast with the sum of 250,000 naira claimed as monthly basic salary in respect of the 8th claimant in this case. It is noteworthy that the appointment of the 8th claimant even came after the 2007 recommendation of the RMBFC, which recommended the sum of 760,076 naira as the annual basic salary of a special advisor in the 3rd tier of government, which has risen supra will result to 63,339 naira 67 kobo as the basic monthly salary of a special advisor. The letter of appointment of 8th claimant captured above, even though came after the recommendation at pages 89 to 91, clearly excluded the recommended remuneration package in the recommendation when it specifically provided for what 8th claimant is entitled to, and equally did not make any reference to any other remuneration based on the said 2007 recommendation of the RMAFC. Besides, a recommendation as contained in the said 2007 remuneration package by RMBFC is ordinarily not binding on the first defendant. See the case of RMO number 2 and the Adekoye and other citation captured. It will only be binding where it has been accepted by the defendants by way of an enactment. The first defendant, represented by the first claimant, and the 8th claimant clearly contracted outside the terms of the said 2007 recommendation by stating in specific terms what 8 claimants will be entitled to as remuneration in her letter of appointment, in contrast with the letters of appointment of the 3rd and 7th claimant, which do not contain any term on remuneration. The 8th claimant cannot claim outside what is approved to her in her letter of appointment, which obviously came after the 2007 recommendation as stated supra. This, in my humble view, is in line with the settled principle of law that parties are bound by the contract they voluntarily entered into and cannot act outside the terms and conditions contained in the contract, and neither of the parties to the contract can alter or read into it a written agreement, a term which is not embodied in it. See the case of Suleiko Communications Limited and Access Bank citation captured, the case of Lagos State Government and Toluashe citation captured, African International Bank Limited and Integrated Dimensional Systems Limited citation captured. Thus, the sum claimed as entitlement of the 8th claimant cannot be justified in view of the peculiar facts and circumstances of this case. I so find and hold. Now, let me consider the entitlement of the other claimants having resolved that of the 8th claimant. As reason supra, the principal remuneration law as amended does not cover councillors. The 9 to 17 claimants in this case, by virtue of paragraph 1 of the statement of facts, are elected councillors. In fact, their certificate of return are at pages 109, 101 to 108 of the record. In view of the above, it is safe to say that the 9 to 17 claimants are not provided for under the principal remuneration law as amended. However, just as stated earlier in this judgment, the 2007 recommendation of the RMBFC at pages 94 to 96 of the record makes copious provision for how much councillors and other members of the legislative arm of local government council will be entitled to. The effect of this is that the 9 to 17 claimants who were councillors are covered by the 2007 recommendation of the RMBFC. And unlike the principal remuneration law as amended, the pertinent question at this stage is whether the said recommendation and the principal remuneration law as they relate to the first to 7th claimants and 9th to 17 claimants can justify the entitlement of the claimant of the sums claimed by the claimants. In answering the above question, let me first start by saying I'm mindful of the submission of learned counsel on behalf of the claimants at page 8 of the final written address, wherein he relied on the cases of relied on an unreported suit number NICN/LKJ/31/2019, the case of Honorable Salami, Lamidi, and 21 others versus Ogorimagogo Local Government Council and another supra, and an unreported suit number NICN/LKJ/24/2020, Honorable Sule Jima and 6 others, and Adavi Local Government Council and another supra, and submitted that the court had relied on the said remuneration law as amended to find in favor of claimants therein, and urged the court to take judicial notice of the said laws. The position of a law that has remained like a rock of Gibraltar that doesn't move except in some few situations is the position that the court remains bound by its previous decisions where the facts and the laws considered in the earlier cases are the same or similar in the cases being subsequently determined. See the case of Biko and another versus Amechi and other citation captured, Braithwaite and Skybank PLC citation provided, Ukulate and Awosanya citation captured. In essence, previous decisions is not to be departed from. It is to be followed where the facts or the law applicable in that previous case are similar to those in the latter case, especially where statute having bearing on the matter has not changed. Departing from previous decision is not a matter to be lightly embarked upon by a court. Court can only be persuaded to depart from previous decisions if the previous decisions were proved wrong, given per incurium, and perpetuating injustice. In fact, in the case of Long John and Black citation capture, Eagle JSC did opine as follows, and I quote, "I find it necessary to stress in very clear terms that this court has no power extrajudicially to overrule, reverse, or nullify its previous decisions, whether on questions of substantive or procedural law. Such previous decisions may inter alia only be annulled by legislation or by judicial decision of the court, given intrajudicially when it is satisfied again, inter alia, that the previous decision was given per incurium or will perpetuate injustice," unquote. Thus, a previous decision of the court can only be departed from where such departure is justified. See the case of VP Industries Limited and Cocoa Industries Limited citation captured, the case of Abubakar and others versus Yaradua and other citation provided. The reason for the above position is because the court has a twin duty to see that 1, justice is founded on a correct view of the law, and 2, justice is not slaughtered on incorrect interpretation and the alter of application of the law and equity. See the case of Asaya and the state citation provided. This court has just recently departed from its decision in the cases relied on by learned counsel on behalf of the claimant as regards the issue of the law and the salary packages recommended by the Revenue Mobilization Allocation Fiscal Commission for reasons given therein. This court in its decision in an unreported suit number NICN/FKJ/07/20 case of Honorable Bello S. Ajiga and 9 others versus Okene Local Government Council and another, the judgment I delivered on the 14th of March 2023, an exercise of its powers under section 315, subsection 3, paragraphs A and D of the Constitution to declare invalid any provision of an existing law made by the House of Assembly on the ground of inconsistency struck down the provisions of the principal law as amended by the 2006 second amended law, which allows to fix remuneration and salaries for the offices listed above for being in contravention of the express provision of the Constitution, placing reliance on the Supreme Court decision in the case of Nwokedi and Anambra State Government and another citation provided. The Apex Court in the case of Nwokedi Supra was also of the view that the scope of political office holders whose names were not mentioned in Section 6, subsection 1, paragraph D of the RMAFC Act 2006 have been expanded via Section 6, subsection 1F of the RMAFC Act. It maintained that a councillor or any local government executive is not within the purview of those offices whose salaries shall be determined and charged upon the Consolidated Revenue Fund of the state by RMAFC in line with Section 32, paragraph D, item N, part 1 of the 3rd schedule to the 1999 Constitution. Just a minute. Thus, the inclusion of the local government councillors by the Anambra State Law number 7 of 2001 in the list of political office holders or public officers of whom their salaries shall be fixed by the Revenue, Mobilization, Allocation, and Fiscal Commission and charged upon the Consolidated Revenue Fund of Anambra State is at variance with the express provisions of the 1999 Constitution as amended. The court further held that the inclusion of a chairman of local government, vice chairman, secretary to local government, supervisors, special advisors, or PA to the chairman, leader of the local government legislative council, deputy leader, and councillors by the Anambra State Law number 7 of 2001 in the list of political office holders or public officers whose salaries shall be fixed by Revenue, Mobilization, Allocation, and Fiscal Commission charged upon the Consolidated Revenue Fund of Anambra State is against the express provision of Section 124, subsection 4 of the 1999 Constitution. It is clear from the above decision of the Apex Court that the RMAFC lacks the power to prescribe or recommend remuneration for any executive in the 3rd tier of government. It was in consequence of this decision of the Supreme Court that this court, in the case of Honorable Bello Ezajiga and 9 others versus Lokoja Local Government Council and another supra, that this court equally struck down the 2007 and 2009 recommendations of the RMAFC as it relates to local government executives. The power of this court was reiterated in the Supreme Court decision in the case of AG Federation and Anuebunwa citation captured. The decision of this court in the case of Honorable Bello Ezajiga and 9 others and Lokoja Local Government Council and another supra as to striking down the portions of the principal remuneration law as amended by the 2nd amended law 2006, which deals with the local government and remuneration packages 2007 and 2009 made by the RMAFC, which the claimants in this case are equally relying on for being inconsistent with the provisions of the Constitution, binds this court. In view of this, the principal remuneration law as amended by the 2nd amended law 2006 and the remuneration packages of 2007 and 2009 respectively as they relate to local government council executive therefore cannot confer any entitlement on the claimants as an illegality cannot be the base of the legal rights. As such, this court cannot enforce illegality. See the case of Alao and African Continental Bank Limited citation captured, Jegede and another versus INEC and other citation provided. As a corollary to the above, the letter of the House of Assembly, Kogi State, dated 21st May 2013, at page 53 of the record, specifically as it relates to implementation of the recommendation of RMBFC 2007 and 2009, as well as the letter dated 22nd May 2008 and 29 December 2011 at pages 57 and 60 of the record respectively, which claimants are equally relying on in this case are equally of no legal value or efficacy. The reason for this is not far-fetched, and it is simply because as reason supra, an illegality cannot be enforced by the court. The RMAFC as reason supra has no power to recommend remuneration for the 3rd tier of government, and in pursuance of which the RMAFC recommendation of 2007 and 2009, which is being referred to in the said letter of the House of Assembly, has been struck down. The House of Assembly, Kogi State, can therefore not rely on the legal, cannot therefore rely on the legal remuneration, rely on the legal RMBFC recommendation for 2007 and 9 as it did in the letter dated 21st May 2013. This is because the House of Assembly cannot implement the legal RMBFC recommendations which have been struck down. Noteworthy is the unequivocal fact revealed on the letter dated 22nd May 2008 at page 57 of the record, which is that the House resolution, which the letter wants to bring to the notice of the Ministry of Local Government and Chieftaincy Affairs, applies to past local government political office holders from 1999 to date, unquote. Quote and unquote, to date, in the context used means from 1999 to May 2008, when the resolution was passed and the letter written. Claimants who served much later during the 2013-2016 political dispensation cannot therefore be claiming under the said letter. Also, with respect to the letter dated 29 December 2011 at page 60 of the record, is also clear that the letter covers only former political office holders of Okene local government from 1999 to date. This means that only an ex-political office holders who served in Okene local government from 1999 to December 2011, when the decision of the House was reached and the letter written, could take benefit under the said letter. Claimants who are ex-political office holders in Okene local government and served during 2013-2016 political dispensation are not covered by the said letter. The clear import of the above is that both letters bear no relevance to the case of the claimants and thus of no evidential value, as they cannot help the case of the claimants. They are thus discountenanced. Assuming the said principal remuneration law as amended and the 2007 and 2009 recommendation are not even illegal and can confer benefits on claimants, particularly the first 7 and 9 to 17 claimants, can the claim of the claimants against the defendant succeed? The answer to the above is in the negative, and I will proceed to explain why. Claimants in this case would want the court to believe that the first defendant is indebted to them in the sum claimed, but they did not place any document before this court to show that they have not been paid as averred, especially where the defendants are alleging that claimants have been paid all that they are entitled to. Claimants who are seeking special damages by way of alleged indebtedness of the defendants to them have a duty to prove it. In the case of Christian versus Umara and another citation captured, it was held as, and I quote, it was the duty of the claimant who asserted the indebtedness of the first defendant to prove it. He who assert must prove. See section 131 of the Evidence Act 2011. See also Dasuki and FRN and other citation captured. Unquote. See also in this case, the case of Estate Petroleum Nigeria Limited and Petroleum Equalization Fund Management Board citation provided. It is interesting to note that claimants who are alleging non-payment of salaries and allowances and that the defendant had paid the sum of 35,455,863 naira 38 kobo out of the total debt of 173,593,789 naira 79 kobo, leaving a balance of 138,137,926 naira 41 kobo, tenaciously hang on the belief that they can establish the outstanding sum against defendants without a statement of account or any other document to clearly show what was paid and the outstanding amount, ditto the date and months owed. Proof in civil claims is on the preponderance of evidence. It shifts and never stays static, but comes to rest on he who fails to supply evidence. It is called shifting burden of proof. See the case of Union Bank and Ravi Abdul and Company Limited citation captured, wherein the Apex Court per baggage GSC held us, and I quote, this is because in civil suits, unlike criminal cases, the burden of proof keeps oscillating among the parties. The Evidence Act 2011 says it all in sections 131 to 134. For the purpose of burden of proof in civil suit, the Act states, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of fact with which he has said must prove that those facts exist too. When the person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. On whom burden of proof lies, the burden of proof is in the suit or proceeding lies on that person who would fail if no evidence at all were given on either side. He went on to quote section 133 and section 134, and stated that the standard of proof in civil cases, the burden of proof shall be discharged on the balance of probabilities in all civil proceedings, unquote. See also the case of Okoye and others versus Nwankwo citation capture. Accordingly, the burden must of necessity start with the claimants in this case, and unless they place evidence before the court, documents showing they have not been paid during the period in contention as alleged, defendants have no duty to provide evidence in rebuttal. See the case of Haydare Trading Manufacturing Limited and another versus Tropical Commercial Bank citation captured. Claimants having failed to tender their statement of account showing they were not paid, as contended by clearly showing how much they were paid and how much is outstanding, the defendants have no duty to disprove what has not been proven. Claimants will only be deemed to have discharged this burden on them where they have tendered sufficient and cogent evidence before the court. See the case of GF4 and another versus Ubaka & Son Nigeria Limited citation captured. I find, therefore, that claimants have failed to discharge the burden placed on them to prove their claims. I so find and hold. One may want to argue that what of the admission of the defendants in the joint statement of defense that claimants were not paid for the period they were out of office, or the seeming admission of the defendants by failure to respond to the letter of demand written by claimants. The court in the case of Joe Iga and Chief Amakiri citation capture, the Apex Court held that, I quote, where a creditor writes a demand letter which the supposed debtor fails to react to, the silence of the latter leads to the presumption of admission by conduct, unquote. See also the case of Demerol International Company Limited and GTB PLC citation captured, the case of Tilijado and Company Nigeria Limited versus Access Bank PLC citation captured, IOM Nwoye and Sons Company Limited versus Cooperative and Commerce Bank Nigeria PLC citation captured. In my respectful view, for an admission to be binding, such admission must be clear and unequivocal and not based on misapprehension. See the decision of the Apex Court per Sanusi GSC in the case of Alhassan and Ishaku citation captured. On admission, he held those that I quote. An admission, to my understanding, is a statement, oral or documentary, made by a person which suggests any inference as to any fact in issue or relevant fact. He cited the case of Nearing Dex and NICMB Limited and Section 20 of the Evidence Act 2011, and went on to state that it also means a statement by one of the parties to an action, which amounts to an acknowledgement by him that one of the material facts relevant to the issue in controversy in the proceedings, not as he claims it to be. He cited another case and went on to state that, therefore, admission, in my view, if it is clear, unequivocal, and cannot be said to be based on any misapprehension of any fact, is binding on the maker, and such maker cannot be heard changing it subsequently or at a later state to suit his supposed new or fresh case or averment, unquote. See also the case of Ogunuhu and others versus Shegboka citation captured. Besides, it is an established principle of law that special damages would not succeed merely on an admission, because even where there is an admission, the claimant still has the onerous task to prove his entitlement to the sum claimed as special damages. See the case of NNPC versus Clipco, Nigeria Limited citation captured, case of Idigbe and EH, Nigeria Limited citation provided, case of SPDC, Nigeria Limited versus Table, number 7, citation captured. It is obvious from the foregoing that the burden of proof rests on the claimants to substantiate their entitlement to the sum claim, even if there was an admission, and which they have failed to do in this instance. In view of the above reasoning and findings, it is pertinent for this court to, at this stage, hold that the consequence of failure to prove their case leaves the court with no choice than to dismiss it. See the case of Ziagu and Gabizi Lingo Pharmaceutical Company Limited and another citation captured is Usikaro and Ishekiri Communal Land Trustee citation captured, Ogbechi and others versus Onoche and other citation provided. Accordingly, the case of the claimants is hereby dismissed in its entirety. Parties are to bear their respective costs. Judgment is accordingly entered.
We are most grateful, Your Lordship, for the
Very well.
well-considered.
A copy of the judgment will be forwarded to you in Lokoja.
As God please.
Very well. So arise for now.